In what is being seen as a major setback to the central government and to Parliament, the Supreme Court has struck down the National Judicial Appointments Commission. The court, a 5-judge bench of the Supreme Court, said this morning that the 99th Amendment, constitutional amendment, which had brought in the National Judicial Appointments Commission that proposed to give more say to the executive in judicial appointments, was unconstitutional. It violated the basic structure of the Constitution. The commission was created by the government as an alternative to the collegium system for appointing judges to the highest courts in the country. While the government has argued that the collegium system lacked transparency, the petitioners who are opposed to the NJAC argued that the word eminent as described in the amendment, eminent citizens who would assist in the appointment of judges, was too vague and would encourage political interference in judicial appointments. That's what is really the big story that's breaking. Let's just get in reactions that are coming in from the court at the moment.
In a historic judgment today by the Constitution Bench of Supreme Court of India, led by Honorable Justice J.S. Keha, the Honorable Supreme Court has declared 99th Amendment of the Constitution seeking appointment of Judicial Commission as unconstitutional. The ground for unconstitutionality is that it violates the basic structure of the Constitution. As per the basic structure of the Constitution, independence of judiciary is a part of the basic structure.
The court has held that this National Judicial Appointments Commission, in which the government would get a substantial say in judicial appointments, interferes with the independence of the judiciary and therefore has been declared to be unconstitutional. From now on, the collegium system gets restored, by which the senior judges select the judges.
Okay, the big question, of course, in some way is, has the judiciary protected its independence or is it protecting its own? I think that's the question that's going to be raised. Jugal Purohit is still there outside Supreme Court with Anusha. Anusha, there have been questions in the past over whether judges should be allowed to appoint their own. On the other hand, there are those who believe that the independence of the judiciary matters more than anything else. Just tell our viewers, who are the main lawyers? I know Fali Nariman argued passionately for striking down the National Judicial Appointments Commission. Who are the other big ticket lawyers who are there, who are opposing the manner in which the Parliament had moved this act?
Well, Rajiv, the cast, if I can call it, was perhaps the biggest, the most powerful lawyers. Ram Jethmalani was there, Bhim Singh, Prashant Bhushan. But let's go to Anusha, who's been following the story through and through. Anusha, who are the main lawyers who are opposing the government's move, the parliament's and the state legislators' moves? And just what was their argument? Because there is definitely, as we discussed earlier, a need for reform. And definitely it isn't easy to provide arguments against what the parliament, both houses and 20 assemblies have decided. Who are these people and what were their arguments?
Jigal, there is not a legal luminary that you can name who did not stand against the NJAC. Starting from Fali Nariman, Prashant Bhushan, Bhim Singh, Anil Diwan, and all the big names you can imagine in the legal world stood against the NJAC. And the key argument, the crux of the argument was that you want to reform a system, but you must reform it in the right way. You cannot bring political interference. You cannot do the politicization. To stop nepotism, there has to be certain ways. And if you look at the spirit of the judgment that has come today, it has said that we are keeping the collegium system at bay, but to add to what we've already been talking, the court has also said that all the petitioners and the government must come forward to this bench, make suggestions about how they can make the collegium system better. So of course, that's one of the progressive stand that the judiciary has taken, that they're now open to some reform, and this is also an admission of the fact that there is clearly a need for reform that must happen.
Okay, and there is also, I believe, some update with regards to whether or not it was a unanimous judgment. Can you tell us more whether it was or was it not?
To begin with, when he said that, Justice Keha did mention at one point that unanimously we have decided few things, but as we try and get more details of the judgment, what we're hearing is it's a 4-1 judgment. Justice Chelameshwar has given a dissenting judgment. What exactly he has dissented on, what are the points, we don't know, but it's a 4-1, which means it's still a majority judgment given by this bench.
Okay, and we expect that the judgment will be available to people like Anusha Soni as early as possible. In fact, we are awaiting the uploading of this 1,000-page document, which has been in the works for about 3 months plus now. At any moment, Rajiv, that will go a long way in making us understand the reasoning behind striking down an argument which was approved by 2/3 of the houses, both Lok Sabha and Rajya Sabha, as well as 20 state assemblies.
Right. We'll come back to you for much more, particularly when we get the detailed order. But, Mr. Khemkar, advocate, is with me. Mr. Khemkar, one of the concerns, I think, that perhaps the judiciary has, and we'll know once the judgment is read, is the manner in which the present environment is. There's a feeling the executive wants to constantly interfere in judicial appointments or in any appointments. We've seen the controversy over FTII, Nehru Memorial, ICHR, ICSSR. In every body today, there is a sense that the government wants to put it its own. So who would have been these eminent citizens? What would have been the process? Law minister and 2 eminent citizens could effectively counter what, let's say, the Chief Justice and 2 judges wanted. Has that been part of the problem? Kamini Jaiswal alluded to it, that the present environment is such that judges and other institutions are suspicious of our political class, whether it's Congress or BJP, that they will appoint their own, therefore we must protect ourselves. This was also the reasoning in 1992, when the original collegium system came into being, but even 22 years later, those fears perhaps remain, that the executive will interfere in the functioning of the judiciary.
There cannot be any doubt that once the executive has a say, it will try to have its own people, because ultimately the executive is the biggest litigant in all the courts. Today we have politicians as personal litigants. The cases against number of politicians.
So therefore it's a bit like the CBI. The CBI wanting to claim its autonomy, and actually in reality the CBI director gets appointed by the government of the day.
Even if they don't try to outdo it, they will certainly try to barter something. They'll try to pressurize that have some of our people.
In that sense, today the judiciary has protected its stuff.
I think that doubt remains. The Supreme Court and the judiciary has reasons for that. But Rajdeep, the problem lies somewhere else. The problem lies with the constitutional provisions themselves. The Constitution says an advocate practicing for 10 years in High Court can be appointed as a judge of a High Court. Now, what is this 10 years of practice? What would be the qualification? Can this be a qualification that I am enrolled as a lawyer for 10 years? Or I have practiced in a High Court for 10 years? That cannot be. This system does not allow law professors to become a judge. This system does not allow researchers to become a judge. This system does not allow law writers to become judges. So the question is that it is actually a flawed system which we are talking of. So Supreme Court and the executive legislature will have to do something about it.
I agree. So therefore the judiciary needs to change its ways, make the system less transparent, and the executive class needs to restore its credibility, because people believe, whether it is today a Prasar Bharati board or any board which is appointed, or even CBI directors are appointed, they are appointed based on their political affiliations.
Right.
So therefore even the executive needs to learn a lesson. The Modi government will have to learn a lesson. The previous Congress government will have to learn a lesson. And that's why state assemblies have passed it so readily. They want to control the judiciary. That is the reality.
There is one more thing which has not been debated in any of these judgments. And that is that there is a whole cadre of lower judiciary which is appointed by interviews, by written tests and all that. That cadre works for 20 years and thereafter they are promoted to the Supreme Court. Now question is that why should there be direct appointments at all? When there is a lower judiciary cadre, why can't you have people with a proven track record who have done well in the lower judiciary only as High Court judges? The Constitution doesn't say anywhere that 50% judges will be directly appointed and 50% will be appointed from lower judiciary. So the question is that the whole meanness is happening because of the direct appointments.
I
have them from the lower judiciary.
I'm joined at the moment by Vinay Tiwari, our managing editor. Vinay, the sense one is getting that both sides had strong arguments. There was the argument that the present collegium system of judges appointing their own lacked transparency, could lead to bias. On the other hand, there was the worry that the executive getting a say in judicial appointments could result in political interference and the judiciary being compromised. The judges seem to have gone 4-1 by the second concern, the concern of the executive interfering in judicial appointments. On balance, has the time come both for the collegium system to be reformed and maybe the manner in which the NJAC was appointed in the present environment only strengthen the suspicions of the judiciary that the political class wants to interfere in their affairs?
Yes, and I think, Rajdeep, if you see the debate that's happened in the last 2 decades or so, ever since this whole system is being debated, I think the trouble has been that there is a lack of trust on both sides, and I guess both sides have some logical reasoning for their arguments. It's not as if one side is completely true. The other reason is the timing here is the problem. The NJAC formation happened in the backdrop of a phase of judicial activism, so to say, and that activism kind of created or pitted the government against the judiciary. I think a lot of the people in the political class felt threatened by the activism of the judiciary in the last couple of years, and then the timing of the formation of NJAC was seen as an attempt to encroach upon that, and I think that is where the problem has happened. It's not as if both sides don't have merits in their argument.
I think that's a good point that you make, that judicial activism, particularly post, let's say, 2005, over the last decade and maybe even more in 2009, with major case of corruption coming before the judiciary or the judiciary itself intervening, coal scam being a good example, where the judiciary even went to the extent of summoning the Prime Minister or then Prime Minister Dr. Manmohan Singh. The question therefore is that yes, there is the fear that the executive has of judicial activism. The judiciary has the fear of political interference. Are we heading for a possible constitutional crisis as a result? Because tomorrow when the parliament meets in the winter session of parliament, they may well have their own say and say, we are determined to go ahead with an NJAC. Unlikely though, given the present circumstances, but the potential does exist given the mistrust that you spoke about.
Yes, and not just a constitutional crisis, Rajdeep, it's also a judicial crisis, because in the last 6 months or so, not one appointment has now happened, because ever since it was notified, the NJAC, not one appointment has happened because the judges have not participated in the new system. And this is actually only adding to the backlog in the higher courts. You will not be able to clear up. In fact, we already have a shortage, and now with no more appointments happening because of a stalemate, you may well head into a situation where the shortage becomes even more acute.
That's right, and you've got even the Chief Justice's own, you've got a case of the Chief Justice to be appointed. Presumably that will be done on seniority, and therefore in the case of the Chief Justice the problem won't arise. But the question that Vinay is raising will affect High Court judges, it will affect the judicial appointment system, where there is a huge backlog as it is right across the board at the moment, because now you will have to wait to see, are you going to have a reformed collegium system? We have to wait to see the order, whether the order in a sense says yes, we will reform the collegium system, will it, or do we return immediately to the earlier collegium system? That's not clear. We'll have to wait to see the order, because Prashant Bhushan was not clear on that point, whether we return as of today itself back to the collegium system.
That's not clear.
I'm presuming we do.
And the other thing, Rajdeep, yesterday off record, some papers have reported that the government seems to be in a mood to consider 1 or 2 of the provisions that they had initially mentioned in the NJAC. There seems to be some, yesterday at least they made that comment, but I think with the judgment, the kind of judgment that's come today, which is probably harder than what they'd expected, it may well lead to a confrontation.
Okay, I just want to get a few more reactions that are coming. Let's listen in to some of the petitioners and those who've argued in the court reacting to that judgment. Listen in.
Sir, what are you feeling when you see that NJAC is struck down? What is the way forward from here?
It's a very welcome judgment of the Honorable Supreme Court. Since we have challenged the constitutional validity of the 99th Amendment Act as well as National Judicial Appointment Commission Act, the validity was challenged because it is going to interfere with the independence of judiciary, and that is the basic structure of the Constitution. The Honorable Supreme Court has appreciated our argument, and now finally by the judgment.
So what is the way forward from here? That is the question. That will it be going back to the collegium system naturally?
Yes. No, they have pronounced in the order, they have specifically said that after the striking down of the 99th Amendment, the earlier system of the Constitution will prevail. It means Article 124A. See, when the amendment has been struck down, it means the Constitution will go back as it was before 99th Amendment.
Was it a unanimous decision or was there a division among the judges?
No, it is a 4:1. So one judge has given its own reasons for upholding the constitutional validity of
Sir, do you think, my final question, do you think that way from here will be a confrontation between the government and the judiciary, because that has been the larger picture. That has been the larger question of people related to this fraternity.
No, see, what I say is maybe the government may have different notions, but the Honorable Court was very clear to the fact that now regarding the independence of judiciary, this has to be maintained. And further, the court has given one suggestion to us that we can give further suggestion to the Honorable Court as to how the collegium system can improve. Because in certain quarters there were said that there are certain drawbacks in the collegium system. Therefore, the Honorable Supreme Court, while maintaining the operation of the Judicial Commission, collegium system as valid, they have also asked for further suggestions from our side as to how to improve the objectivity, accountability and transparency of the collegium system. But that 3rd November has been fixed as the date. So we'll give our suggestion on 3rd November to the Honorable Supreme Court.
So there you have it. The NJAC has been struck down for the moment, but yes, the court has taken cognizance of the matter that yes, probably not everything is right as far as collegium system is concerned, and that needs to be strengthened, and that the court is open to.
Okay, we're going to get plenty more reactions. We'll be joined by several more lawyers, including those who were involved in the actual hearings in the court, to get a sense of what this judgment actually now means. I think clearly the fact is that we are entering a grey area as to exactly what is the way forward. The court has clearly ruled against the NJAC. The Supreme Court has declined the government's appeal to send the matter to a larger constitution bench. The only leeway the Supreme Court has given is that a constitution bench will hold a hearing on improvements of the current collegium system, and that hearing will take place on the 3rd of November. So the one little window, in a sense, that has been given is that the hearing will be on November 3rd to see ways in which the collegium system can be improved. But the fact at the moment is that the National Judicial Appointments Commission, as presently enacted by a law of Parliament, has been struck down by the Supreme Court. What happens now to the way in which judges are appointed in the interim period is a question that we will raise. Do we go back to the collegium system? And what does this mean really for our political class? Remember, 20 state assemblies and parliament passed this. Has the Supreme Court simply drawn a Lakshman Rekha with our political class? And has the mistrust between the judiciary and the executive and legislature reached the point of no return? Plenty more questions to be raised.